The Appellate Division, First Department, is now in session. Good morning and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Bay. Appellant.
Appellant Jonathan Rosenberg for Huey Buey, Your Honor. Good morning.
Good morning. Respondent.
Good morning, Your Honor. Samuel Goldfein on behalf of the people.
Each of you have 6 minutes.
Thank you.
The Balonis versus Overstrom.
Good morning, Your Honor. Tom Mulaney for the appellant.
You have 6 minutes.
Good morning, Your Honor. Peter Kerwin for the respondent.
You have 5 minutes. Matter of G children is submitted. Martin versus the City of New York is submitted. Alonzo versus 215 Audubon Avenue is submitted. Wesco Insurance versus Travelers Property. Appellant. Appellant on Wesco Insurance. Is the respondent present?
Good morning, Your Honor. Meg Reed on behalf of the respondent property. The appellant was on at the initial check-in, Your Honor.
Is the appellant present on Wesco? Okay, the appellant has 6 and 2, the respondent has 8 minutes. I will call it again at the end of the calendar to see whether the appellant is back on. People versus Gutierrez, submitted. Pelote versus Barine Apartments, submitted. Way Family versus Sage Point Financial.
Good morning, Your Honor. Jonathan Newman for the appellant.
You have 5 minutes.
Thank you, Your Honor.
Good morning, Your Honor. Stephen Mellon for the respondents.
You have 5 minutes.
Thank you.
Freeman Mechanical versus City of New York.
Good morning, Your Honor. Donald Carbone for the appellant.
Okay, you have 5 minutes and 2 in response. Respondent.
Good morning, Your Honor. Alan Rosinas for the city.
You have 5 minutes.
Thank you, Your Honor.
People versus Clark.
Good morning, Your Honor. Colin McGrath for the appellant.
You have 5 and 2 in response. 5 minutes and 2 in response.
Thank you, Your Honor.
Good morning, Your Honor. Luis Morales for the respondent.
You have 5 minutes.
Thank you.
Hackman versus 244 East 48th Street is submitted. Danco Enterprises versus LiveX Media is submitted. Swords versus Gona Realty.
David Horowitz for the defendant appellant, and I'd like to request the opportunity to reserve 1 minute for rebuttal.
Okay, so you have 2 and 1.
Thank you.
Respondent.
Good morning, Your Honor. Nathan Monroe Yavna on behalf of respondent James Sorge. 3
minutes. Finkelman versus Hashkama Brooklyn is submitted. Matter of BA Children is submitted. Epstein Becker versus Sampson Management is submitted. Rosenblum versus Trinity Hudson is submitted. Morales versus Marion Avenue is submitted. Wesco Insurance versus Travelers Property is the appellant present.
Yes, Your Honor. Sorry, Max Gershwar for appellant.
Okay, so you have 6 minutes and 2 in response, and the respondent has 8 minutes. I remind the attorneys to keep their microphones muted until their case is called for argument. I would also ask the attorneys to please not speak over the judges. That's our usual rule when we're in live oral argument, and it's even more necessary in virtual oral argument. People versus Boy. Appellant, please proceed.
Your Honors, good morning. Jonathan Rosenberg for the appellant, Huey Buey. May it please the court. The first point in this case I will discuss briefly, which is that we believe the trial counsel was ineffective as a matter of law based on the record in this case. And this is a cumulative record that we believe shows that trial counsel did not meaningfully represent the defendant, both during hearings and at trial as well. The facts of the case, I think you're aware of them. It's fairly straightforward. We have an individual who, as the record shows, no record of driving, no record with any issues with the law. He is the driver for an individual who has a company car or a company driver, and he is alleged to have had cocaine and I believe an opiate in his system prior to driving this person during the course of her work. He gets into an accident because he has a seizure during the course of his driving, an uncontrolled seizure, which at trial, the prosecution makes the argument that this seizure was caused by his use of drugs, as he had admitted pre-Mirandized and post-Mirandized to police in the hospital room. And they link that this was a foreseeable cause of the accident, that his seizure, rather, I should say, was a foreseeable event. This seizure, he's never had a seizure in his life, the record demonstrates that he ever remembers. But in any event, the tragedy is significant because the complainant does not only suffer brain injury, but requires tremendous rehabilitation.
We're aware of the facts, counsel. We're aware of the facts of the case. You said that your primary claim is ineffectiveness. Why don't you focus in on where you feel that it was this ineffectiveness?
Thank you. And I think I should add, it should have been primary as number two. Number two really is our primary claim.
Okay, so with regard to the ineffectiveness, did you do a 440?
We did not. And
so we don't really know the underlying facts that the attorney may have been proceeding under, or whatever.
We do not.
Okay.
Your Honor, and that certainly is a weakness in trying to say.
So why don't you get to the point that you think is the most important? Does it have to do with the statements, or does it have to do with the whether the statements were made willingly? What is it that you want to say?
That's correct. The real question in this case boils down to whether the defendant was in custody at the time. Officers testified that, or they interviewed him for 3 hours in the hospital.
So he was in the hospital, and presumably it was natural for him to be in the hospital. He had been in a very serious accident, although he was the driver. He was injured, I believe, or at least there was some seizure or some medical issue involved. So he was brought to the hospital, not unusual, because there was police. The police had to come. Police accompanied him. He wasn't in handcuffs or anything else. Was he in custody during that period? Were there suggestions? Was there something to suggest that he was in custody? Did the police say something? Did they do something? What?
Well, as Officer Smith testified to, he was not free to go. Now, the test obviously is not what Officer Smith thought. We can admit the test is a subjective, reasonable.
It's the Uckel test, isn't it? People versus Uckel.
That's correct, Judge. And the question is, would a reasonable person think they were in custody or free to go? There were anywhere from 1 to 5 officers who were in the room, including one who accompanied him to the bathroom. And the claim of the officers, or the argument, was, okay, well, this was just interviewing, and we were investigating an accident over the course of 3 hours. Clearly from the record, they were trying to elicit a confession. They asked him about drugs. They got him to take a test with his blood serum. They asked him about had he taken any substances. He was very cooperative. This was over a course of about 3 hours from 7 to 11 p.m. while he was in the hospital. He was not cuffed, Your Honor, as you alluded to before. And we know being cuffed is not the one measure here. I think that it's very powerful that the statement from Officer Smith saying he was not free to leave during that period of interview, as they said during the hearings, he was not free to leave is the key thing here. And I don't think he'd ever have the belief.
Again, is it whether they thought he was free to leave or whether whether the defendant thought he was free to leave?
Right. And I think that translates to the defendant not believing he would have been free to leave. And now there is a case, People v. I believe Thomas, from this court that says if a person's in the hospital and under certain conditions, it's a case-by-case thing. It's not clear are they handcuffed. It's a case-by-case test of.
Okay, so counsel, you've spoken about the handcuffs, but can you be more specific about the other factors that you are suggesting? You've mentioned the handcuffs quite a lot. You've mentioned what the officer said. What about the other things? So specifically, how many police officers were around him? Who were they? What did they say to him? Did they, you've indicated that they accompanied him to the bathroom every time he went. Is there some other suggestion, something else?
There are, Judge. Officer Smith and Detective Choi were present almost the entire time, we believe, or at least were interviewing from 7 to 11 in their words. We also know Officer Choi was the one asking a lot of the questions, and that we know there was a lack of attenuation between Mirandizing, which is very important in this case. If we look at People v. If I recall, People v. Paulman, I think Court of Appeals case from 2005, there was a lack of attenuation where there was no change in environment between what they were talking about and then or Officer Smith saying, okay, here are your rights, and by the way, you have the right to counsel. And they asked us questions later.
Counsel, this is Judge Mendez. How about the time that elapsed between the statement he made to Officer Smith and Detective Choi, and then the time that elapsed until the statement he makes after having been given his Miranda warnings? Because he made the statement, the first statement was about 8:50 or so, and then the second statement was about 11 o'clock in the evening. So that's about 2 hours time.
And that's correct. And to also address Justice Renwick's question, the details surrounding these statements, we're talking that he confessed to prior cocaine use during the day. Each of these statements were made while Mr. Bowie was in the emergency room when the detectives were present. We know other detectives are officers.
So your time is really best, but so what specifically would you zero in and where you say the ineffectiveness was?
Right. So during the hearing, there was essentially no defense raised as to the issue of anything involving the Miranda or the law on attenuation. I mean,
are you saying that there was attenuation, or that and what is? Are you saying that 2 hours was not enough time to attenuate it when it was still in the same place with the same people under the same circumstances? Is that what you're saying?
Justice, that's exactly right. It was the same room, same kinds of officers, same kinds of questions. They just wanted to get the information out. And then Miranda was sent forward, and it's vitiated at that point. The attenuation being there's no change in environment, there's no change in the setting of who's there and the kinds of questions they're asking. And I think what shows an intent to get a confession out, we see on page 38 of our brief, we show Detective Choi in hearing saying, they said, why did you ask Mr. Bowie's Miranda rights later? And why did you not ask him earlier? And he goes, well, he was not under arrest. Okay, but that was a sole basis for not giving him the questioning. Is that correct? Well, I didn't deem any criminality at that point. So they were investigating criminality, and Mr. Smith, or Officer Smith, was much clearer, saying that he wasn't free to go. He said he wasn't under arrest. I didn't feel there was a reason for me to give him interrogation warnings because I wasn't interrogating. He kept saying this, but then the lawyer asks, so you made a conscious decision to not give him the warnings? Answer, yes. It was he knew he could have given them. He chose not to, is the key here, because he was there to investigate a crime. He wasn't there to investigate an accident. They knew what was going on with the accident. They knew who was injured. They knew he was.
So you're saying his investigation wasn't under emergency circumstances where he needed to find information about what happened. He was doing more of a long-term investigation, more of an extensive now underlying investigation, I guess. It wasn't under emergency circumstances.
It certainly was not under emergency.
Are there any other questions from the bench? Thank you, Counselor. Respondent.
Good morning, Your Honors. Samuel Goldfein on behalf of the people. I would like to address, defendant's statement. Before I get to the first and second statements, I'd like to note that even now, at this oral argument and in the brief below, defendant does not contest the third statement, which was made the following day to a different group of officers in a different location. It's recorded, preceded by Miranda warnings. It's completely proper. It's fully attenuated. They make no argument about that at all. So even assuming there was any impropriety with these first two statements, which there was not, there's a third statement where he admits to using cocaine. And then putting all of that aside, the cocaine use is largely irrelevant to this defendant's conviction. He is convicted based on the strength of the toxicology reports, showing that defendant had 10 times the limit, the dosage of tramadol in his system of prescription opioid.
Why don't we talk about, can you just answer the question about the attenuation the next day with the video? How long was that after?
So after the first statement is made at 8:50 p.m. the day before.
Yes, and we know. And the next one, 2 hours later, around 11.
And then 1:45 the following afternoon. So 13 some odd hours from the second statement. Different location, different officers. There's no reference back. I mean, in the first statement, defendant makes the most incriminating comment. He says, "I did cocaine the night before, and also at 3 p.m. before the crash." In the second statement, he doesn't mention the cocaine before the crash. The officers never ask him about that. And on the third interview the following day, again, there's no reference back to this initial mention of cocaine the day before. So the most incriminating statement is that first one. And again, the cocaine is largely irrelevant.
And does that prejudice the jury? I think that was obviously it was allowed to come in. So the question is, was that made under circumstances that it shouldn't have been and shouldn't have been able to come in, even though the last video came in?
Right, Your Honor. So the first statement, defendant is not in custody at this time. He's been involved in a major accident.
Well, that's the question, right? Whether or not he was in under
custody.
Circumstances that would have.
Absolutely, Your Honor. So the standard, of course, is a reasonably innocent person in the defendant's position. Defendant had just been involved in a serious car accident. His statements suggest that he blacked out and then woke up in the hospital. The police testify that this is standard procedure. They accompany everyone to the hospital when they were moved from the scene of a crash, regardless of criminality. And the types of questions that these officers are asking are geared at an investigation. What happened here?
But the rule with regard to investigation, isn't it that, when there is an emergency circumstance, for example, it's most often used when, someone comes on the scene and they say there were two people and there aren't two people and one of them has fled and might be in the vicinity. And so now you're asking questions to gain enough information to obtain the person who might not be there. This was not that kind of thing. It was, they knew who the driver was, they knew who the passenger was, they knew who the victim was, they knew what the car was. There was nothing that was happening that was an emergency situation that would have, they would have lost evidence had they not asked it. There was already blood work taken by the hospital, which was protocol. So what was the reason for not giving Miranda when they walked up and knew that this person was the driver? There were police all over the place. One would think that it would have been not unusual for a police officer to ask another one, do we know whether he was drinking, on drugs, or some medical issue before they even walked up to the defendant? So why is this now? Why are you calling? I know I just gave you a long question. I apologize. Why is this a circumstance that qualifies for them to be able to ask all of these questions, as you call it, an investigation?
Absolutely, Your Honor. So first of all, I don't think there's any suggestion that this was an emergency, that they were operating, there was a need to do this quickly. I don't think that's the case, but I do think that this is an unusual circumstance. The defendant suffered a massive seizure and there was this big accident, and the police are trying to find out what happened. Was there any criminality involved? Because defendant could have simply suffered a seizure. There could be no crime at all. So they don't really know what's happening, and they're taking this time to try and figure out what's going on. And I would point out,
hadn't a test been done already for cocaine? They say they don't know it, but it would seem to me under the, that would be the first question they would ask one of their fellow officers. That would have answered the question right there.
Well, I agree that they did know about the cocaine, but I don't believe that answers the question. I mean, defense counsel brought out on cross-examination that cocaine is not going to cause this kind of seizure, at least not in the quantities that defendant had consumed it in. So the knowledge of the cocaine still doesn't answer the question. Was there a crime here?
Well, I don't know that they found out. I'm not sure at what point they found out about the massive amounts of the
tramadol, Your Honor.
Exactly. So still,
the
cocaine was the cocaine use. It was the knowledge of the cocaine. The cocaine is in the blood work. They had that before they started asking the questions.
That's correct, Your Honor, but that still doesn't answer the cocaine use at some unspecified time.
I mean, if someone was smoking marijuana and they smelled the marijuana, they would arrest him. You're saying that this person had cocaine in his blood, and they had that information before the questioning started, and that wouldn't have been enough to say he was driving, he was the driver, he had cocaine in his blood to arrest him? And then a basis to read the Miranda?
I'm not, Your Honor, the police could have read his Miranda rights, but the question is, were they required? And I would point, Your Honor, to People v. Scott, as a Court of Appeals case from 1984, that this type of questioning, have you been drinking, is appropriate after an accident for the police to investigate, to assess, was there criminality, was there a crime here? And I believe that
And was that at the hospital or at the scene, that question?
I believe that question was at the scene, Your Honor, but I don't see how that distinction...
At the scene. So we're not talking about that. We're talking where they did not have any other way to ask the questions. That's a very different fact pattern. We're talking about in a hospital after the blood work is done, after it's determined that he has cocaine in his blood, then, and you know he's the driver, and you don't give him Miranda. That's what we're talking about.
I take Your Honor's point. I would then note that, again, there's another statement that's fully attenuated where he admits this, and that more importantly, the cocaine is irrelevant to this conviction. Defendant is convicted because he has 10 times the dose of tramadol in his system. And because
you're absolutely right, except it is the reason for the questions and for him not having been Mirandized. You're absolutely right about the other drug, for sure.
Are there any other questions? Thank you both.
Could I reserve just a 1 minute rebuttal?
You didn't reserve time, so.
Thank you, Jeff.
Yeah, I'll give you a minute, just very quickly, go ahead.
Because they brought up weight of the evidence, I would just say the tramadol, at sentencing, it was on the record. This was a substance that was, he'd been taking for years without issue.
10 times the amount? There was 10 times the amount.
It doesn't, you're right, Your Honor, it does not justify the amounts that they brought out at the prosecution, and that were not defended well, by the way. I would also say, though, that the fruit of the poisonous tree, it's very clear. I don't need to tell the court this. The cocaine comes out, it knocks it all, the lack of Miranda, the tramadol doesn't get in. And then, or maybe it does, but we don't know because it was never done properly.
Thank you both.
Thank you.
The Bellinius versus Overstrom.
Good morning, Your Honors. Tom Mulaney for appellants, the Overstroms. I'd reserve a minute for rebuttal if that's all right, Your Honors.
Yes.
Thank you. The issue in this case is one of basic contract construction and the New York rules of that. What the trial court did was, without making a finding that the contracted issue was ambiguous, it looked outside of the four corners of the contract to interpret it.
Counsel, I'd like to ask you something about
a successful outcome. Wasn't that the test? Wasn't that the contractual requirement in order for plaintiff to be entitled to the $75,000? There had to be the lease and easement had to be upheld, and at the end of the day, the lease and easement were upheld.
No, Your Honor. The successful outcome is defined specifically in the contract as being an enforcement of the lease and easement completely in the Overstrom's favor. And what the Overstroms sought was a cancellation of the easement and the lease.
They sought that later on, didn't they? That's something which developed later on. They decided to go after it, but to maintaining the lease and easement so that they had the rights provided by the lease and easement, that was what was at stake when that agreement was made.
It did come later on, but the Overstroms were totally entitled to bring whatever claims they wanted to in their sole discretion.
They developed a theory which they developed later on can undo what would appear to have been the clear contemplation of the parties when the original agreement was entered into.
I don't think it's undoing what's in the clear contemplation of the parties. The parties clearly contemplate that the Overstroms may seek whatever relief they wish. It is in paragraph 6, the next paragraph. Moreover, in paragraph 5, there is a reference to the withdrawal from the record of the lease and easement agreement from the county clerk's office. Now, if that happens, there's no easement. So,
Counsel,
yes,
sorry,
sir.
You finish your statement, and then I have a question about whether or not we should even be addressing this appeal or whether it should have been dismissed because of the timeliness of it. So.
Thank you, Your Honor. Well, let's just get right to that, Your Honor.
Yes.
It is correct that I did appeal the order and then untimely appealed the judgment. However, the law
did you appeal the judgment at all, or did you appeal the order and and not include the appeal of the judgment in that notice, in the notice of appeal? You referenced the order, not the judgment. And the judgment was filed before the notice of appeal?
There was an order, notice of appeal of the order. Then there was a judgment. Then there was a notice of appeal of the judgment. That is true by the.
That was months later.
Weeks later, I think, but perhaps months later.
January. The judgment was in October of 19, and then the appeal came in January.
Okay.
That's months.
Yes, that's true, Your Honor. The law in the First Department is almost invariable that where the order is incorporated in the judgment, as it is here, even an untimely appeal of the.
I think what you mean is identical, where the judgment is identical, not necessarily. You're talking about 5520 subsection C?
Yes.
55? Okay.
I think it may also be identical, but I think either one applies here because the appeal of the judgment necessarily covers everything that's in the order, and the First Department has, in all the case law that I cited, and I think it's almost invariable, where it is the case that the appeal of the order is timely, that it is considered in the interest of justice.
5501C specifically deals with the situation that we have here. Isn't that so?
I think that is so, Your Honor.
And 5501C is not in your favor.
Well, the words of the strict words of the statute are, it is true, not in my favor. However, it is also true that I'm not the first one to have done this, and that in cases where something identical to this has happened, the court has always allowed.
Doesn't the situation which we have here fall within matter of Aho, the Court of Appeals decision? I'll grant you it's not a recent decision, but it's been repeatedly followed since then.
Well, I believe that the respondent did raise matter of Aho in the briefing. I think that there is a slight difference, if I recall Aho correctly, in that there was a defect in the appeal of the order itself, as opposed to here, what is the case is that the appeal of the order is timely and there is no challenge to that. And what the appeal of the judgment, although untimely, is that's the only problem with the case.
Any other questions?
Would you say that this? I do. Would you say that this case is more like Saide versus Calderon?
I have to say I'm not familiar with that case.
Well, where 5520C is used, where the judgment comes after the where the judgment comes after the notice of appeal is filed, but it is identical to the order.
Yes, I think that's right, Your Honor, and it is
the substance of the order, in other words, and the judgment are the same. The judgment doesn't add anything that the order didn't already have in it, which is what the basis of the allows the discretion, is that it's not different.
Correct. I mean, that is correct, Your Honor. The cases that case and the other cases that are relied upon in my brief generally say, in layperson's terms, that it's sort of a form over substance, perhaps, that the appeal of the order, if the court were to go and hear the appeal of the order and the order were reversed, that would leave a judgment that has nothing underlying it. I mean, almost by definition, it would have to be reversed, but for...
Even though 5501C would say you should not be permitted to appeal, you should disregard that.
Well, that is... I mean, there is an interest of justice exception, and that is followed. That is followed almost invariably. I did not. Yes, I mean, I did not find a case where there is an appeal of a judgment, and the order itself is either identical to the judgment or it incorporates without any difference. The court,
Thank you.
4 or 5 times.
Thank you. Respondent?
He's muted.
Yeah.
He's muted. You're muted, sir.
Thank you. Good morning, and thank you. The 2008 modification agreement, which is at issue here, clearly and unequivocally obligated the defendants to pay our clients $75,000 if there was a complete ratification of the lease and easement agreement. A ratification agreement, which is actually defined in the original.
Counsel, I have a quick question on that.
Yes.
If we were to agree with the appellant's argument, then essentially, in my mind, there's no consideration because the easement was in consideration for that use of the 1 acre at $10 a month or a year or something. I mean, those two kind of go hand in hand. But if I accept the appellant's argument, then where's the consideration, correct? I mean, you kind of need both, right? They kind of are married. You can't separate them.
Yes, it's a variation of the argument that the lease and easement agreement had benefits and it had burdens. And you have to take the benefits with the burdens and you can't separate them. And that's what the motion court.
Right. And didn't the appellant actually buy that 1 acre?
Yes.
Okay. So
no, well, they sold it, I should say.
Well, they sold it, but yeah, but they got the benefit of the 1 acre, but now they're also trying to get rid of the easement too.
Right. Yes. And I was going back to the original decision where the courts found their tribal issues of fact. The Appellate Division Second Department years ago, when I was much younger.
We were all younger. We were all younger.
Yes, specifically said or defined ratification that you're assenting to the terms of the agreement. So in this instance, the motion court properly held that if you have burdens and benefits, they're both ratified. And when the Appellate Division Second Department ultimately specifically held that there was a ratification of the agreement, our client was entitled to the $75,000.
I guess the other way you could look at it is that if he wants to get rid of the easement, then the whole deal with the 1 acre should be off too, because they go hand in hand. So if they want to get rid of the easement, they got to give back the property or they got to undo the sale. So I mean, if you want to carry it to its logical conclusion.
Yeah. Yes, Your Honor.
I don't think they want that though. Okay, I got it. Thank you.
And then I was just going to say, just following what you were saying, Your Honor, is that you can't separate the two. And when you look at the appellant's original motion, the only issue that they raised, and they actually moved first, we cross-moved, was to say that in their determination, the agreement required a successful outcome, and that they define a successful outcome as the court adopting every theory or cause of action in their action number 2, which they started after we signed the modification agreement. And once our client signed the confirmation and express ratification of lease and easement agreement, which is also in the record, that essentially that was the document that allowed the Second Department ultimately to hold that both the benefits and burdens of the lease agreement have been ratified, thereby entitling our clients to the $75,000. With respect to the jurisdictional argument about that, clearly, if you don't timely file notice of entry of the judgment, your right to appeal is terminated. Although there is, as Appellant says, interest of justice, you could exercise your rights, but I don't necessarily think that should occur in this instance. So for those reasons, I believe that the motion court.
But you do agree that 5520 allows us to exercise our discretion in this circumstance?
Under limited circumstances. I mean,
where it's identical, yeah.
Yeah, I don't believe it.
Why is it not identical here about the judgment and the order?
Well, one has a monetary sum in it, yes. So they're not identical.
Why isn't this covered by 5501? 5501C, which provides that there is an exception, but this case doesn't fall within that exception, so that you've got a notice of appeal filed for the order and not for the judgment. It's only when the judgment comes before the notice of appeal, if the notice of appeal is filed from the order, that it then covers the judgment. But that's not what you have here.
Yes, I agree in the matter of auto control.
So you have a specific situation here which falls within the statute Why would we go to a statute which does not deal with the specific situation that we have?
I agree that matter of Aho controls and that the right to appeal doesn't have a right to appeal.
Well, isn't that the very reason for 5520C, for when the circumstances are, they apply, 5501C may apply, but where it's identical or where you have an order and a decision that where it would be, where you're doing the very same thing, that rather than to allow that to happen, that's what discretion is about. That's why that discretionary provision is there, isn't it? Isn't that why it's there? Otherwise, what would it be there for?
I think it's there more for pro se litigants, but
it says that? Does it say
no,
that? It's there for pro se litigants? I don't think that the statute is just.
I've seen your honors granted in those circumstances, but I think more or equally as important.
And I don't think the cases it's been applied to were pro se cases involving pro se litigants.
I was just pointing out when, in the interest of justice, when I think the court should exercise that.
Well, that would be different than the way the court has in the cases that we have, wouldn't it? What you're saying.
Slightly, yes, but I was trying to pivot back that the motion court was correct, and the lease and easement agreement was completely ratified, and therefore we're entitled to the $75,000. So either way, either the appeal is dismissed or the appeal should be affirmed, or the motion court should be affirmed.
Thank you.
Thank you.
Appellant?
Yes, I'd like to get to the issue that Justice Owing raised and Mr. Kerwin dealt with. Whether there's consideration or not in the lease and easement agreement from 1989 between two parties who were not involved in this litigation is not relevant to the narrow issue we have here, which is whether the modification agreement has been honored and complied with. And here, the Overstroms were entitled to seek a relief, even that one that we all might agree seems unlikely because it might challenge the issue of whether there was consideration for the lease and easement agreement. Not only did my co-counsel at the time make it in good faith, it was not opposed or rejected by anyone at the time. Justice Winslow upheld it because there is clear language that says the easement terminates with the termination of the lease. But it was Respondent's Counsel who himself moved the court and made the application in order to cancel the easement. And that is found in the record at page 125, where the trial court's order says, now on application of the law office of Fred L. Seaman. Nobody said at the time that that's unjust or frivolous. And quite the contrary, it was victorious. And there is, in the modification agreement, there's no reference to burdens and benefits of the lease agreement. And in fact, there are other considerations that come into play here, such as Mr. Vebler-Eunice was no longer indemnifying anyone for the legal fees of this litigation. This litigation did not terminate within 12 months of the closing of the property. It was costing Mr. Overstrom a significant amount of money in fees to get the benefit of his bargain. Those are the considerations that the court should be looking at. I respectfully submit.
Thank you. Thank you both.
Thank you.
Thank you, Your Honors. Thank you, Peter.
Wesco Insurance versus Travelers Property.
Good morning, Your Honors. Max Gershwire for Wesco. First, I apologize for lack of video access. My office is working on getting me a camera. In presenting this case to you this morning, I can't help but feel a certain sense of deja vu, because this is the fourth time I've argued this precise issue before this court. The issue of whether the standard additional insured lessor's coverage applies to injury sustained on a public sidewalk abutting the premises leased to the named insured. In each such case, and in every other one this court and the other state appellate courts have decided, the courts have found that coverage applies. And there's nothing novel about this case setting it apart from the others. In many of those cases, and as stated in our brief, The courts have rejected the position of Travelers in the lower court that coverage under the endorsement is precluded if the additional insured was obligated to maintain the area and is thus potentially at fault, because the endorsement does not limit coverage to the lessor's vicarious liability. Rather, the endorsement applies to liability arising out of the ownership, maintenance, or use of the leased premises. In New York City public sidewalk slip and fall cases like this one, the lessor's liability is governed by Administrative Code Section 7-210, which imposes liability on the owner of the abutting property. As the courts have confirmed, since that liability thus arises out of the ownership of the property, coverage is triggered under the endorsement for the policy issued to the lessee of that property. And apart from the ownership prong of the endorsement, the courts have also found coverage under the use and maintenance prongs of the endorsement, whereas here, the portion of the sidewalk where the accident occurred provides direct access to and from the leased premises. Here, the underlying plaintiff was using the sidewalk in exactly that manner, to walk from the leased premises, which he had just departed as a customer of the bank, to the parking lot serving those premises where he had parked his car. Thus, any liability faced by Waldman would clearly arise out of the use of the leased premises. For these multiple reasons, this court should find that Travelers has a duty to defend and indemnify Waldman on a primary basis in the underlying action. Wesco is entitled to the other relief it seeks, a judgment declaring it has no duty to defend or indemnify Travelers named insured Capital One, because it indisputably is not an insured under the Wesco policy. If the court has no questions,
Okay, and no questions from the panel? Thank you. Respondent?
May it please the court, Meg Reed on behalf of the respondent, Travelers Property and Casualty Company of America. In determining this issue, the court is bound by the terms of the additional insured provision, which more accurately states that the owner is an additional insured, but only with respect to liability arising out of the ownership, maintenance, or use of that part of the premises leased to you. And in order to interpret what precisely that part of the premises leased to the tenant is, we have to look to the lease. Here, there's no dispute that the lease reserves the area of this injury to the owner for both maintenance and control purposes, and that the lease.
But counsel, I understand that that's word, but let's just look at it in terms of it's a bank. Someone's got to walk in and out of a bank. It's not like they're going to be carried out of the bank. So this is part of, he slipped and fell, if I'm correct, right outside the bank. As he's walking out, he slipped right outside the bank. So aren't there cases that says that that's part of the demise premises? I mean, you have the demise premises correct in terms of it's set forth in the lease, but there's an ingress and egress part of the demise premises, at least a little bit, a minimal part of it that I think courts have viewed are part of the demise premises, or at least a factual issue there, no? I mean, it's not like he slipped and fell 10 feet or 5 feet from the entranceway to the bank. He slipped right outside of the bank, unless I'm wrong.
Respectfully, Your Honor, in my opinion, and under the case law that I'm happy to go through for you, Your Honor, it would not change the outcome, whether it was 5 feet or 100 feet. If it was.
Well, what about, for example, the case of 1515 Broadway? Wasn't the dispositive fact there, and isn't that really what we have here, that the accident occurred in the course of an activity necessarily incidental to the operation of the space leased? This sidewalk, as my colleague said, they can't very well levitate into the bank. They have to traverse that path. So why isn't that the same as in 1550? Why isn't this sidewalk incidental to the operation of the leased space?
Well, returning to the language of the policy, the liability here has to arise out of that part.
Use, out of use. Why isn't this arising out of the use?
Your Honor, the courts have repeatedly focused on that part and limited it where the lease is expressed and defines the scope of the lease premises to not include the area.
So what does use of the premises mean then?
The use of that part of the premises is precisely that, Your Honor. That part of the premises that is leased to the tenant, that they have control over. It would.
You have to come and go to that leased premise.
Counsel, your argument seems to be limited within the four walls of the bank. That's what your argument seems to suggest. So then basically the bank shouldn't have any customers coming in then. If your argument is only limited to the four walls of the bank, how are the customers going to get into the bank?
Well, respectfully, Your Honor, turning to the case law, for example, General Accident versus Travelers, a First Department decision where an employee of the tenant was injured outside the leased premises, but still on the owned premises, the court focused on that part of the premises leased to you, the named insured, and found that there simply was no coverage.
If what they meant was to limit it to the four walls of the bank, use of the premises was not really the way to phrase that.
In my opinion, Your Honor, the focus has to be liability. And where is the liability derived from here with respect to this owner of the entire shopping center? That liability is derived from their ownership of the entire shopping center, not just the interior. If the injury occurred inside, then absolutely their liability would be derived from that part of the premises leased to you. But their liability here is not derived from ownership, maintenance, or use of that part. It is derived from their ownership of the entire premises, their failure to maintain it, their control over the sidewalk, just as much as it would be the parking lot. And you cannot somehow draw a line by proximity. The lease does not provide to that. Turning to some of the cases where the lease does not address the leased premises, where the court, for example, ZKZ Associates versus CNA, which was a certified question to the Court of Appeals. There, this is one of the cornerstones of the subsequent jurisprudence on the issue. And there, the sidewalk where the injury occurred was just at the threshold of a parking garage. And the court found that in the absence of a controlling lease provision, quote, thus by implication, this was part of the lease premises and therefore there was coverage. There is no need for implication. Implication would not be appropriate here where the lease is express. It's a very limited issue before Your Honors today. And that is where the lease expressly provides that this sidewalk, that's part of a sidewalk that serves various storefronts and is reserved to the owner and expressly is not part of the lease premises, whether that liability that arises out of that ownership, that maintenance, that use that belongs to the entire shopping center can trigger this coverage that in part refers to that part of the premises leased to you.
Are there any other questions for counsel from the panel? Thank you.
May I address one more decision, more
yes.
recent? Public Service Mutual versus Nova is another First Department decision where coverage was found, but the policy language there was distinguishable. It did not refer to liability. It was with respect to the ownership, maintenance, or use. And the underlying trial court also found expressly by implication that that area was part of the lease premises. And I further would refer Your Honors to Chappaqua Central versus Philadelphia Insurance. There it was likewise an employee in the Second Department. That decision, more recent than both Allenby and Frank, which the appellant relies upon, there the court found that it was beyond the risk contracted for and therefore was not part of the lease premises, even though those stairs were necessary to access to that part of the premises leased to you. And it was an employee, which similar to a patron is obviously tied to that premises, but nonetheless was beyond the scope of the leased premises, and therefore there was no coverage.
Thank you.
Thank you, Your Honor.
Appellant?
Yes, Your Honor. Just to correct, I think a factual inaccuracy both in the argument, Traveler's argument, and in their brief. If you look at the photographs in the record, page 286, clearly shows that the public sidewalk abuts only the leased premises. It does not abut any other portion of the shopping center. So clearly, the shopping mall's owner's potential liability here can only arise out of its ownership of that portion of the mall that was leased to Capital One. So in addition to the arising out of the use portion, this also triggers the arising out of the ownership portion of the endorsement.
Any other questions from the panel? Thank you. Thank you both. Way Family versus Sage Point Financial.
Yes, good morning, Your Honor. Jonathan Newman for the Appellant Way Family Trust. May it please the court. In this case, the lower court recognized that had this been an attorney-client case under the continuous representation doctrine, the claim would be timely under the First Department's jurisprudence as expressed in Wagner. However, the lower court declined to apply the rule to this case because, and this is at page 5 of the record, that the court stated the authority plaintiff cites for this proposition is specific to legal malpractice claims against an attorney's former firm where public policy specific to attorney-client relationships during the legal proceedings are at play. And then the court cited the quote from Wagner that clients cannot be expected to jeopardize a pending case or relationship with an attorney during the period that the attorney continues to handle the case. However, this same public policy applies equally in the context of an investment advisor, as the court said in Wainwright versus Matrix, Southern Department, not this court, but a sister
Counsel,
court.
I have a question.
Yes.
The way I understand this is that the broker investment advisor, that's the individual who does allegedly the bad things to this account. I mean, it loses a lot of money here. How does that affect the employer? I mean, because the broker is not named as a defendant here. The broker's former employer is named as the defendant. So even if I were to agree with you that there could be a continuous treatment doctrine or continuous representation, how's that the case? It's the broker that continues to represent the plaintiff because the plaintiff allows the broker to take the accounts with him wherever he goes. So if I were to agree with you and say, yeah, okay, there's a continuous representation, but that would be with the broker, not with the defendant employers or former employers. So how do we do that?
So this court has repeatedly stated within the attorney-client context, such as in
That's
Wagner.
very different. The attorney-client, I mean, you're talking about, we're under as attorneys a different rubric compared to the financial industry. I mean, there's a lot of going on with attorneys because attorneys, they share information with the firm, they talk about things together. That's why you have these conflicts, procedures to go through when you bring on a new client. I'm not so sure that's the same case when you talk about financial industry. I think their goal is to make money. The attorney's goal is to represent clients, right?
I think they're not considered professionals in the same way that these other categories of people are.
So they actually, I would respectfully state, this court has stated that they are considered professionals in that same exact way. And actually that's been cited in a case heavily relied upon by respondents themselves, the Zarif case. This court stated that investment advisors are professionals and that the continuous representation doctrine does apply.
Correct, but does that trigger or link in the professional's employer? See, that's the difference. That's what I'm trying to get at. Here with lawyers, if the lawyer leaves, the law firm may still be on the hook. In this case here, the investment advisor leaves. The question is the former employer investment house on the hook? So and that's what I'm trying to have you try to convince me that that's the case.
Sure. So this department in Wagner, in New Kayak, and HNH never, and the other cases cited, never stated that that was the crux, that the attorney who committed the malpractice somehow was sharing information with the firm or was discussing information with the firm. A broker and an investment advisor has to have discussions with the firm the same way that an attorney would have with his firm, because the broker / investment advisor is under constant scrutiny under the rules of the industry.
Did you allege that in your complaint? I'm not so sure you made those allegations in your complaint to try to link when you're now naming the defendant former employers. Unless I misread that, I didn't see those kind of allegations in your complaint that the actual broker shared all these financial informations with the defendant and former defendant employer, and the defendant employer acquiesced or approved of all the transactions that the broker did. I didn't read those allegations.
So respectfully, it actually is in the complaint. The complaint alleges that the brokerage firm, under industry obligations, the firm has to review every single broker transaction. And that's on a daily basis, and there's on a monthly basis. And the complaint alleges that the firm did acquiesce, or that they failed to actually review the transactions here because the transactions were not compatible with the customer's investment profile. So that is in the complaint. I would state, however, that this argument that Your Honor is raising—
you turned my question around. I understand that it's the obligation of the defendant, former employer, but the question is the defendant, that the broker himself, when you said that the defendant, former employer, the investment house, has to make sure that the investments are within the parameters of what the client wants. That's all dependent on what the broker investment advisor tells the financial house, right? I mean, that's what they're operating on, because these financial houses, they inconceivably cannot be able to get or speak with clients, all the clients, on an individual basis. They're relying on their brokers to tell them, or at least put in reports, what is it exactly the clients want. And that's what I'm missing in terms of what did this broker actually convey to the investment house? Because in order to get liability, they got to know what's going on, right?
So I'm not sure. Two issues with that. Number one, this was not an argument raised by the other side or by the court below. So I'm addressing this for the first time.
I understand that. I understand that. I'm just, when you want to get continuous representation doctrine, it brings up a lot of questions in my mind. I mean, I understand it's not there. So if it's not there, we don't have to talk about it. We can move on. I'm done. Okay.
I'm happy.
I don't want to waste your time. You can continue on your other issues.
Now, your claim basically relates to occurrences in 2007 and 2008 by Yanis, right?
The original
and the action is brought in 2018. Do I have that?
Slightly different. The original.
Am I basically correct about that? I mean.
So there was a FINRA filing that was made in 2016, and then under the FINRA rules, the statute of limitations get told during that period. So the case was filed in state court in 2018, but there was an earlier claim that had been filed pretty soon after.
You brought the action in December of 2018, more than 2 years, right after the FINRA. The FINRA decision was completed in September of 2018. Is that correct?
Yes, and then that was the dismissal, and then the case was filed.
You say it's told from 2016 to 2018.
Yes, until the dismissal of the claim itself. So,
any other questions? Any other questions for counsel? Thank you, respondent.
Thank you. Good morning, everyone. Stephen Mellon for the respondents. The role of a brokerage firm is to supervise a recommendation of securities, which is something that occurs at a moment in time. Here, as we've discussed, the moment in time is in 2007, 2008. There's no ongoing duty of a brokerage firm to monitor and make sure additional advice is given, even if the brokerage firm had an ongoing relationship with the customer, which we know didn't happen here. Everything ended in 2009. So, as Justice Owen,
I just want to be clear about something. So, and the plaintiff, or the principals of the plaintiff, or the principal Gregory of the plaintiff, he's aware after 2007, 2008, he sees statements seeing that there's marked decreases in the value of the assets. Isn't that so?
That's absolutely correct. He gets a monthly statement, and in fact, the complaint alleges that by 2009, by the time the account left SagePoint, the account is already down over $500,000. That's 40% of the total amount he invested in investments he was supposedly told were quote unquote safe. And they've lost 40% of their value in a year or two. So and this goes more to the discovery rule aspect of the case, but our contention is obviously he's on notice by 2009. Hey, there's something funny going on here. I lost 40% of my money. I can't just sit and say, well, but he says they're safe. He says they'll come back. If you've made an investment and you've lost 40% of your money in the first year or two, it obviously was not a safe investment, whatever the individual said to you. So I do think that's relevant in terms of when the plaintiff should
and Sage Point and the time frame for Sage Point that's their time frame, because then Yanez leaves and goes to other brokerages. So Sage Point's connection to this comes to an end.
That's correct. They're completely out of the picture as of 2009. Mr. Yanez leaves and the plaintiff's accounts go with him. So they have nothing to do with it. They have no idea what's going on with the investments. They don't know if the plaintiff has liquidated them or if he's holding them. They don't know what advice he's being given. They have no opportunity to know any of that, and obviously no duty to someone who's no longer their customer. So I think that, as Justice Owing touched upon, we're not really talking about what is typically understood as the continuous representation doctrine or the continuing relationship doctrine, because there was no continuous relationship between the plaintiff and the defendants after 2009. Because they left Sage Point in 2009, they never had a relationship with the other defendant advisor group ever. So they're essentially bootstrapping their continuing relationship.
And whatever exception there is for this in terms of lawyers going from one firm to another, there is no reason to apply that exception in this context.
That is my view. And it's remarkable that in all the case law from this state, not just this department, but the other departments as well, the only times it has ever been extended where a firm becomes responsible for an individual who has left and has been gone for many years is in the legal malpractice context, in the attorney-client context. And my friend acknowledges that there are no cases on anything else, not doctors, not accountants, and certainly not financial advisors. And essentially his argument is, well, why not? It seems the same to me. It seems like the policy is the same. I think the legal relationship is properly treated as unique, and it's distinct from the relationship with someone who recommends you investments. I'd suggest there's at least three reasons. Number one is, in the legal context, it's very hard for an unsophisticated client to understand how their case is being handled, whether it's being handled well or poorly, while it is still ongoing. Unlike an investor who can pick up his monthly account statement and see how his investment is performing. Does it match what I was told about these investments being safe? Number two, an investor can easily get a second.
I'd say, actually, counsel, on that point, actually, you touched on a very interesting point. You know, for law firms, it's usually a legal malpractice claim, right? That the former client is suing, and the fact that the attorney left that firm doesn't really absolve or shield the law firm, correct? Because the legal malpractice has occurred. I think in a financial situation, or a financial institution situation, I mean, you have these losses. It's a 40% loss. There's always that possibility that that could be reversed, right? And that there is no loss. So that, but in the legal context, if a legal malpractice or a claim has occurred, you can't really change that result. So that's probably, that just goes to the continuous representation thing. I mean, it's less appropriate in the financial services where you can go after a former employer, and more appropriate in the legal context. I'm not sure if you follow what I'm saying.
I think that's exactly correct. If you've blown the statute of limitations, if you've waived an argument that you shouldn't have waived, those things happen. They're done. It's a matter of history. In fact, you can pick up the file and see that now. The client may not understand it yet until the consequences are visited on him down the road, but the malpractice has already occurred.
Right. Okay. Thank you.
Thanks. Thank you. It's a very good point. I think another key difference is in the financial context, a client at any time can easily get a second opinion on his accounts simply by showing your account statements. Say, hey, this is my portfolio. Is this safe? In a lawsuit, if you want to ask another lawyer for his opinion, you got to review an entire file. You got to know a whole history. It's not really feasible. And then finally, and maybe the most importantly, a legal malpractice claim usually cannot be filed until the underlying case is resolved. And it not just as a technical matter of accrual, but also because it doesn't become clear, as Justice Owing pointed out, your lawyer has messed up until something happens in the case itself. With investments, the value might drop away. You might lose 40% in the first 2 years, and you know something went wrong here. In a lawsuit, until 5 years down the road, you lose summary judgment because of something your lawyer screwed up, and you say, hey, wait a second, what happened? It's complete.
Thank you. Are there any other questions from the panel? Are there any other questions from the panel? Thank you. Thank you both.
Thank you very much.
Freeman Mechanical versus City of New York.
Good morning, Your Honors. This is Donald Carbone on behalf of Freeman Mechanical. Your Honor, I think initially the first thing we should recognize here that this proceeding and the wrongful default of Freeman Mechanical is going to affect the economic survival of the company. And Your Honor, in the default on the record on appeal on page 2073, it ends with, this default will be recorded in the city's online procuring passport system, and it may affect Freeman's ability to do business with the City of New York. Your Honor, the word may is an understatement. Effectively, Your Honor, if you're defaulted on a City of New York project, you are not going to get another job from the City of New York, because no bureaucrat who is making a decision whether you are a responsible bidder or not in a subsequent matter will take the chance and have to live up to the fact that if you...
I understand what you're saying about the importance of this decision, but the case in front of us relates to what is the standard of review on an Article 78 proceeding. That's what we're talking about.
Okay, and you're...
The fact that, and I don't doubt what you're saying, I'll accept it for present purposes, is what I mean to say, is that this has devastating impact on your client, but that doesn't change whether this Article 78 proceeding should be reversed.
Well, Your Honor, my argument dovetails into the standard that my client was entitled to at the default hearing. And my position is that the A.I. Smith case should be the controlling precedent here. And that says when you face a debarment, which I say this is a de facto debarment, then you should be afforded a full-blown hearing. At the minimum, Your Honor, we should have been afforded a hearing where we had a full and fair opportunity to present our evidence, to examine the evidence that was presented against us, and not be ambushed at the hearing for the first time, where the hearing officer, who's prejudiced, I'll get to that in a minute, presents for the first time an analysis.
Were you given an opportunity to make submissions in regard to that?
Your Honor, submissions, Your Honor, the answer is yes. However, submissions after the fact are not really submissions where you're defending yourself. What the hearing officer did here is the hearing officer said, we are going to apply the Procurement Policy Board rules. Those were the rules adopted by the hearing officer. The Procurement Policy Board rules entitle the parties to full disclosure before the hearing even takes place. None of that, Your Honor, was provided to us. We had a time extension request that was submitted sometime in October of 2016. We put in 40 pages of analysis, and the 40 pages of analysis was supported by a critical path method, analysis, and a narrative. 6 months later, they give us a time extension request without comment, saying we're entitled to an additional 2.5 years, 981 days, to complete the project. Your Honor, that granting of the time extension request in March of 2017 was not in a vacuum. There had to be an analysis behind that at the DEP, analyzing our CPM analysis and saying it was justified, and therefore the delay was not our fault. That was never produced. Then, Your Honor, 5 days after they gave us the time extension for 2.5 years, they then send us a notice of deficiency telling us we delayed the project for 700 and some odd days, totally ignoring the fact they gave us a 2.5 year time extension. So now you have, Your Honor, a conflict at the DEP. Ms. Velasquez, who was the hearing officer, signed off. She was the assistant commissioner, the agency chief contracting officer. She signed off on a 2.5 year time extension. You have someone, Mr. Osick, who's in the Department of Engineering, and now what he does is he disregards that. Now we have a hearing, okay? So now we're having a notice of opportunity to be heard. If you look at the hearing notice itself, which is written by the hearing officer, she is taking certain facts as facts and evidence. She says in the notice of an opportunity to be, to be heard, she says, Freeman's lack of compliance provides sufficient basis for concluding that Freeman is in default. Freeman has failed to diligently prosecute the work. Freeman's failure to perform change orders is a problem. Given the problematic shutdown, Freeman's health and safety is...
Are these findings, counsel, this is Judge Mendez, are these findings that she's making, or is she simply giving bullet points of the arguments that the agency was making at the hearing?
No, she's not giving bullet points. What she concludes with, based on the foregoing, there is sufficient reason for the commissioner to conclude Freeman's lack of compliance.
So she's not summarizing their argument at the hearing.
That's what the DEP's attorney is going to tell you, that what she's doing is she's summarizing the claims against Freeman. That is not what she's doing. She is making an affirmative statement in the notice that Freeman, these are the things that you're guilty of, so to speak. We get to the hearing, okay? Now, there's no way.
And what happened at the hearing?
Okay, well, first of all, we have a $6.5 million contract. We have a contract that's going to last over 5.5 years.
My question to you is, were you able to present your facts, your version of the facts at the hearing, to have the hearing officer take your contentions and then make a determination?
Okay, Your Honor, the answer is no. We were not given a full and fair opportunity to present our case.
What do you mean by a full and fair opportunity? Because you submitted documents, correct?
We did submit documents.
Did anyone testify on your behalf?
Well, Your Honor, we only had 2 hours. We had a contract that's going to last 5.5 years, just extended to 2.5 years. So now we have an 8-year contract, over $6.5 million. And
counsel, you didn't answer the question, I don't think. Did you have witnesses?
We had witnesses, yes. But the hearing officer said at the very beginning, we're having a hard stop of 2 hours. And in the middle of our witness, Frank Marginelli, the principal of Freeman, the judge, the hearing officer, cut off the testimony and said, we're done here. And that was the end.
So I've tried not to have a hard stop, and you have passed your allotted time and you have response time. So let's hear from the respondent and then we'll hear from you again.
Thank you.
Good morning, Your Honors, and may it please the court, I'm Alan Racinas, representing the city. Your Honors, the city does not like to default contractors. It's a nuisance, it's expensive. The reason that Freeman was defaulted here was that they had shown that they were not capable of doing the work. On the debarment issue that my colleague on the other side raises, he has never given any evidence in any of his briefs that debarment would result. In fact, he's kind of...
I think this is one of the issues that sort of percolates in the case. So why are you giving them an extension? Because you did give them a partial extension.
So, Your Honor, the extension issue is really a red herring, because the way that the system works, and you can see this in the standard operating procedure that's pertinent on page 2576 of the record, partial extensions of time, which is what Freeman received here, are for the purpose of processing paperwork, including payment paperwork. And the way the system works is you can't continue to make payment unless the contract's substantial completion date is still in the future. And so these are very rote. They're granted all the time because public works projects go over the initial allotted time all the time. And it has nothing to do with whether or not there's the past performance or the current performance is proper. And that's why if you look at the contract, it says the city doesn't waive any rights under the contract, including the right to default, just because there's an extension of time granted. The certificate itself says essentially the same thing. The certificate of extension and this is the key point, Your Honors, the reason that that Freeman was defaulted here is not about time per se. It's because they had shown that they couldn't do the work. They were not able to seal what we refer to as pump number 3, one of the 8 pumps that they were supposed to both seal and replace. They put on a steel plate that didn't work. They tried the steel plate again. It didn't work. They kept submitting proposals, and it was their obligation under the contract to determine the means and method of sealing the pump. They kept submitting, but DEP had the right to say that their means and method would be unsafe if it would be. They kept submitting proposals that the DEP deemed unsafe. So there's really.
I'm sorry, if you would just, you finish your sentence. I want to ask you about the hearing itself.
Yes, Your Honor, I was just going to say that there's really no basis to say that the extension has anything to do with the whether or not their performance to date had been adequate under the contract.
So what about the hearing? Because we have to determine whether there was a full and fair opportunity, a meaningful opportunity to be heard. And I understand that the counsel is just saying that there was a hard stop. The judge cut his witness off in the middle of the hearing. There was material that your office had generated that hadn't previously been provided, and that the court refused to provide while it was presented in the hearing. Did those things and others that counsel refers to deny them of a meaningful opportunity to be heard?
I don't think so, Justice Thornwick, and here's why. The crux of the issue for that, well, there are a couple of reasons. First of all, they were able to submit additional submissions, voluminous submissions afterward that the hearing officer reviewed and responded to, the assistant commissioner reviewed and responded to in detail in her 18-page single-spaced determination of default that starts on page 2056 of the record. The main thing that Freeman is saying is, well, you heard Mr. Carbone today say, oh, well, they must have determined that the delay was not our fault. Well, that's just not true for the reasons I just said. They also say in their papers that, Freeman says in his papers that there must have been some calculation about the nature of the delay. Well, really, first of all, it's not clear. There's no evidence that there was, rather than just an analysis of the case that was, verbal or just in a person's head. But more importantly, they knew from the notice of opportunity to be heard that there was that there was an alleged delay. That's really all they needed to know to be able to prepare for the hearing. And they came to the hearing. They said, no, the delay wasn't our fault. They clearly had, we disagree with their justification, their rationale, but they had all the notice they needed to know what the allegations were against them, and they responded at length. That was a big part of what their response was, both in paperwork and at the hearing.
But you presented paperwork that, if you're saying all they needed to know was that, all you needed to know, you knew the same thing. Why did you need to prepare some in-depth analysis of it for the court? And then doesn't that put them in a different position when they're not able to see what that analysis was that you prepared? That's what they're saying. There was discovery they didn't get.
Well, a couple of points, Your Honor. I actually don't think that there's anything that's on top of what there's no memo that I'm aware of that we didn't provide to them that we provided to the court. But the other key point is that counsel is wrong when he talks about the board rules. He's talking about board rule 4-09. He talks about that in his reply brief. That concerns disputes that arise during performance. That's where it says they're entitled to discovery. That's not applicable here. The applicable provision here is board rule 4-08, which is the one that deals with defaults. That just says that standard is the same as the due process clauses standard, which is they have to simply have the protections in the procedural protections that exist in the contract, which here were notice, at least 2 days notice, which they got, and an opportunity to be heard, which they got. So,
Councilor, any other questions from the panel? Thank you.
Thank you, Your Honors.
Okay, Your Honor, one thing is that there was something supplemented at the hearing There was
Yes,
a
what was
reference.
that?
There was a reference to a delay analysis that was never presented to us, that was given to the hearing officer, and which was referred to in her determination, but never produced. Even as we sit here today, that analysis was never produced, so we don't have an opportunity to rebut it.
Yes, that's what I was referring to as discovery, an alleged analysis by the DEP.
It certainly exists because the hearing officer is referring to it. Additionally, when you look at the contract and the purpose of the default of the time extension request, look at this SOP and also look at Article 13.7 and 13.8. It clearly says the purpose of a time extension is to allow the contractor to perform. However, in this case, Raymond was prevented from performing since December of 2016. And certainly after we got the time extension in March of 2017, we were not able to perform before we got immediately after the time extension, before we had the default hearing. And also the final argument is the hearing officer is the one that wrote and signed off on the time extension request. And Freeman's argument was, from a practical point of view, if we gave you a 40-page analysis for time extension and you agreed with it without comment, then you were agreeing that we were entitled to a time extension on the merits. That should not have been decided by the hearing officer, Ms. Velasquez. She was an advocate for the DEP. Her time extension grant was at issue. She should not be determining that. And although the time extension grant did say it was part, for payment purposes only, it did not say solely for payment purposes. And additionally, that's a red herring. Freeman was not.
Counsel, let me ask you a question. I'm sorry to interrupt. This is Judge. I have a quick question. Did you not know, or were you unaware of the fact that that could happen? In other words, the hearing officer could be the person that's actually signing the time extension. You were unaware of that situation?
Your Honor,
going into this contract with the city, were you not aware of the fact that whoever signs those time extensions could end up being the hearing officer if there's a dispute?
Your Honor, I would say that we were unaware because when you look at a contract, every contract has the implied covenant of good faith and fair dealings.
That's not answering my question. You're taking the position that the person who signs that time extension should not be the hearing officer because it's a conflict. And my question is were you not aware of that kind of situation, that could arise? You were never advised of that? Or the city?
Well, certainly, Your Honor, I don't believe Freeman was ever advised of that. We were not the lawyers at the time. I don't think Freeman, Your Honor, I've been representing clients with the city of New York for over 32 years. And I've been involved in multiple. It's never been the city never says when you sign off on a multi-million-dollar contract, oh, by the way, at some point in time, if there's going to be a default hearing, we're going to give a prejudiced hearing officer.
So no, of course not. But since you've said that you've disclosed that you've represented many clients before the city, this type of situation is not unusual, right? I mean, this has never happened to you where the person signing off on the extension is not the hearing officer, or that has happened in the past?
No, Your Honor, when I've been involved in default hearings, it's never been the person who, it's always been like a commissioner. If you had any cases with the Metropolitan Transit Authority, you have the director is going to be the person who's at the default hearing, and he will, the chief engineer is the person who makes the recommendation. So you have a layer of impartiality there.
Thank you. Any other questions? Thank you. Any other questions from the panel? Thank you. Thank you both.
Thank you.
People versus Clark.
Good morning, Your Honor, and may it please the court. Colin McGrath, in association with the Office of the Appellate Defender. I represent Ms. Davia Clark, the appellant. Ms. Clark's conviction should be overturned because she was convicted by a jury that didn't understand the law. The jury asked a question during its deliberations that expressed, on the face of the jury question, clear and obvious confusion about the elements of either robbery or larceny in the fourth degree. When the jury asked that question...
Counsel, I'm sorry to interrupt. I have a question. This is Judge Owen, and I want to focus on the question with respect to the burglary tools, that charge in the indictment.
Okay, Your Honor.
Okay,
yes.
And I'm curious to know why, because from my reading of the transcript, during Miss I think it's Every's testimony.
Miss Early, Your Honor?
Early, yes. The loss prevention officer. It was clear to me that what she was testifying, they didn't have the evidence anymore, the magnet.
That's correct.
Right? I'm just curious, why wasn't that made a larger issue at trial? Or it just seemed like there was an objection, not an objection, but something that alerted the court that that's not the same piece of evidence that was recovered. And I'm just curious why that wasn't explored further. And it kind of just was raised, and then later on during cross, they kind of made an issue of it. It's not being there anymore. I thought that was, it's a big piece of evidence, right?
Understood, Your Honor. And I'm not prepared to speculate on trial counsel's strategy in representing Ms. Clark.
All right.
My best explanation is that the possession of burglar's tools is a misdemeanor, and while that's a gaping omission in the prosecution's evidence at trial, the core focus really is on, for counsel, the felony charges, which are fourth degree larceny and robbery. And so that would be my best answer for why that wasn't.
I got it. Thanks.
Well, why isn't there a clear inference that this was a burglar's tool?
Sorry, could you please repeat the question?
Why doesn't the evidence lead to the inference that this was in fact a burglar's tool that had been, they didn't have it anymore, obviously, but that what had been recovered at the time was a burglar's tool?
The evidence was equivocal. There was circumstantial evidence about the security officers finding security tags in the dressing room. The evidence of property found, garments and bags.
That had been removed from items of clothing.
Presumably. But there was no evidence that showed.
Items of clothing found with like 4 or 5 tags on them, the anti-theft devices. Obviously, you wouldn't expect that one item of clothing would have 4 tags on them. So they had to have been removed somehow. And wasn't there an inference that this piece of metal that had been recovered was in fact a burglar's tool used to remove those tags? What's the weakness in that inference?
There's no connection between that circumstantial evidence and the item found in the bag. There's no confirmation that item was even capable of removing. Sorry, Your Honor.
No, I guess you're getting to my point. What was the evidence that this was a magnet? A magnet is such a simple thing to identify, especially a large magnet. It would be connecting to most every piece of metal one had. So it's a simple test to test a magnet. You don't need to be in a laboratory. And yet the person who testifies says, no test. I didn't know if it was a magnet. It was a magnet, she says, but she didn't test it in any way. No one did. And then there was no magnet at trial.
Correct. There was no confirmation that object had any sort of magnetic properties to it. Ms. Early said that she never tested it. And she even herself conceded that it's possible that it wasn't magnetic. So for that reason, there's enough doubt.
Wouldn't it have to be magnetic to achieve the removal?
Yes, Your Honor. My understanding from the trial testimony was that the mechanism is only capable of removing these tags because it has a magnetic effect to it.
Which was not determined.
Correct.
And was not there to be found.
Correct.
So wouldn't that be a weight against the weight of the evidence in this instance?
I would agree with that. Absolutely.
Any other questions for counsel?
Yes, I think maybe if you go back to your first point about the question by the jury notes.
Your Honor, I'd like to focus on that for a moment. The core problem was that the trial court responded to that question with a simple yes. Yes, a person can be found guilty of robbery, but not larceny in the fourth degree. The problem is that that question showed clear and obvious confusion about the elements of either robbery or larceny in the fourth degree. And at that point,
the question was a yes or no question, wasn't it?
It was a yes or no question, but it made evident that the jury didn't understand the law. And the response, yes, didn't clear that confusion. It allowed the jury to remain confused about the law and resulted in the jury convicting based on a confused understanding of the elements of one or both charges. The court had a mandatory obligation under CPL 31030 and the case law to make sure that the court understood the law and provided a meaningful response to the question. And yes, in light of that confusion, was not a meaningful response.
Any other questions for counsel? Thank you.
Thank you, Your Honor.
May it please the court, Luis Morales for the people. If I may pick up where my friend left off with CPL 31030, that statute tells the court to give such requested information or instruction as deemed proper. And as Justice Friedman pointed out, what was requested was a yes or no answer. To impute confusion to the question is doing precisely what the court sought not to do in reading tea leaves. There are certain questions. Sorry.
Go ahead, finish your thought.
I think there are certain questions that could have elicited the response that co-defendant, not defendant's counsel, had proposed, but those were not the questions that were asked of the court at the time.
So as to the burglar's tool, what is your view how that conviction is consistent with the weight of the evidence?
Sure, Your Honor. Juries draw inferences all the time on circumstantial evidence. We openly acknowledge, and it was always the people's position, that it had been lost, and there was no testing of it. To get to the fact that it was not tested, I mean, we're in a loss prevention office. There's a great deal of merchandise.
If you had cocaine, would you be able to charge the person with possession of cocaine? If you said it was cocaine and then there's nothing in the package?
Absolutely not, Your Honor. Those statutes require the chemical testing to prove.
Well, here, or a gun that's not operable. Here we have a magnet that is,
piece of metal.
Not just that the magnet's not present, it's that it's the simplest thing in the world to test, and nothing is tested. And why isn't this a weight of the evidence? Why couldn't this easily be weight of the evidence against the weight of the evidence?
Well, Your Honor, it's certainly something the jury can take into consideration.
Something we can take into consideration.
Of course, as can Your Honors. If I may just take a step back, though, unlike as an initial matter, unlike guns and unlike narcotics, there is not an operability requirement. For instance, hypothetically, if I had what I thought was a booster bag, a bag with aluminum foil or some metal, and it turns out that it didn't work, that doesn't make it.
I beg your pardon?
If you have an object that is a burglar's tool and it happens to not work, it's still a burglar's tool, and that it is designed in the statute. It says designed to facilitate the offense involving larceny by taking.
Except it couldn't possibly be so designed. This is not the bag where you can still use it as a bag. This is a piece of metal where if it doesn't work, it's useless. It's like any other useless piece of metal.
Right, but there was an authenticated demonstrative. There was the officer pointed out from her experience that she was familiar with these, and then there's just the fact that items go into the dressing rooms with security tags, and they come out without tags, and others are riddled with security tags in a fashion that is not the way Bloomingdale's affixes these tags. So the most reasonable and the only reasonable inference, even in the face of not having the magnet or Early's concession that sure, it's possible it was not magnetic, is that these tags were taken off with something, and that this item that looks like what is a piece from within the Bloomingdale's magnetic sensor was recovered, that was the item. We don't have to rule out every possibility for it.
Well, you're making the jump that piece of metal is the thing that removed the tags, but you're not sure because you don't know it's simply a piece of metal.
A piece of metal that looks like a very highly specialized piece of metal that's fit to a cone to specifically affix onto security devices, and then something was used and something was recovered that looked like just like that, and you have tags that are removed and then other tags that are found.
And yet such a piece of metal, not the size of a dime or a penny, but something sizable and thick enough and heavy enough, one would think you could not work hard enough to keep it separated from other pieces of metal. And the witness says, I didn't test. I didn't know if it was, she didn't test that it was a magnet. She didn't know for sure if it was a magnet. It seems it would be very hard not to know if such a piece of metal was a magnet. It would be so hard to keep it from other items. That maybe goes to credibility or goes to, the fact that this wasn't the piece of metal she thought. It just is. Anyway. Why don't you move on to a different point if you have one about the other issue?
Any other questions for counsel? Thank you, Mr. Morales.
Thank you, Your Honor.
One point in response to what the respondent said. When the jury asked the question, that's at issue here, the court wasn't constrained to simply answering the question as posed by the jury. Where the court sees that the question presents confusion, the court has a duty under the case law, under the decisions of the New York Court of Appeals, to inquire about the nature of the confusion. Sorry,
so a judge is supposed to give meaningful, interpretation or meaningful explanation. Was this very narrow, or was this the kind where the judge could have given meaningful explanation about this? I mean, it's not like necessarily other cases.
True. This is a unique circumstance. The question was quite precise. At the same time, it showed profound confusion about the law. And at that juncture, it was really up to the court to inquire further. There's a duty for the court to investigate, and it's up to the court to sort of to shape and fashion its own response in that context. But it had an obligation to do more than simply say yes, and at the very least inquire into the nature of the confusion, or as counsel had requested, offer to recharge on the elements of robbery.
But that's not what they requested. They simply wanted an answer to a question, and the court gave them the answer.
The court gave them the answer, but again,
don't you think that if they wanted some a recharge, if they wanted to hear the charge again, they would have said, Judge, we need to hear the charge on robbery and we need to hear the charge on larceny. They didn't say that. They said something totally different that could have been answered with a yes or a no. And the court did that, gave them the answer. What they did with the answer is up to the jury. Don't you think?
The court did give them the answer that they asked for, but at the very least, the court should have inquired into the nature of the question to determine whether the jury was in fact confused on the law.
But the question was clear. The question
was clear, but the jury wouldn't have any reason to ask the question if they understood the charges. So
we're speculating, I think.
Robbery.
Now we're going into the jury's mind as to why it is that they asked the question in the first place.
Well, there's no real speculation required because the confusion is obvious on the face of the question. Robbery requires force. Fourth degree larceny has a value component. And so if the jury understood those two legal elements for each respective charge, they would have seen, of course, you can convict on robbery and not larceny in the fourth degree.
Any other questions for counsel?
No questions.
Thank you both. Mr. McGrath, you did this on a pro bono basis?
Yes, Your Honor.
The court thanks you and your firm for the time and effort you put into this appeal. Good job. Good job on both of you. Thank you both.
Thank you, Your Honor.
Sorge versus Gona Realty.
May it please the court, David Paul Horowitz for defendant appellants. I focus on the contradiction and the critical foundation facts in the original and proposed amended complaints. These were not alternative theories based upon the same fact. Instead, they are diametrically opposed foundation fact. Plaintiff cannot simultaneously be an employee and not an employee. Pleading an alternative where claims arise from the same foundation facts is permitted, as highlighted by this court's decision in Gonzalez versus Concord, cited by plaintiff respondents. But Gonzalez apply a contradictory method cannot coexist. In Gonzalez, the proposed amendment presented no new facts, only a different theory of which plaintiff wanted to proceed. Here, plaintiff's proposed amendment a new.
Is there not, Mr. Horowitz, is there not an issue of fact as to how many employees the defendant may have had? I want to turn your attention to that issue because there are other people that they're hiring to do the work. There's principals of the defendant's entities. There's the plaintiff himself. Isn't there an issue left open as to whether you get up to that 4-person mark?
And I apologize for this point, the feed cut out for a moment. I believe you're asking about the number of employees of each entity in order for them to be liable under the New York City or New York State human rights law. And the law is quite clear that principals are not counted, and each of those entities has less than the required number of employees. And I don't believe there's a question of fact about that. There's speculation on the part of plaintiff appellant respondent, but not a real question of fact. Again, the point I focus on the contradiction in the pleadings was I don't even think this court should and can get to that. But on that question, there are insufficient number of employees for each entity and to be liable.
Thank you. Any other questions for counsel? Thank you. Respondent.
Morning, Your Honors. Nathan Monroe-Yavna, representing respondent James Sorge. May it please the court. Your Honors, in denying defendant's motion to dismiss, the trial court properly looked to the well-pleaded allegations in Mr. Sorge's complaint, not to the
How do you get to the possibility of 4 employees here?
Look to Mr. Sorge's allegations in his complaint and in the materials he submitted in opposition to the motion to dismiss. He alleges the following employees: himself, Joka Palusevic, Nicole Kotaj, Vieko Kotaj, and if you look in defendant's reply brief on appeal, they appear to admit that Gina Kotaj is also an employee. So there we have 5 right there. And because this is a motion to dismiss, again, the standard looks to Mr. Sorge's allegations in his complaint, not to what defendants have put in. Now, defendants have, one of their arguments is that they've put in what they contend is documentary evidence sufficient to support dismissal. But I think, if you want to talk about documentary evidence, let's look at this issue of the number of employees. Where are the payroll records? Where are the tax records? Where are the HR records? These, in theory, could show that defendants either have 4 or fewer than 4 or more than 4 employees. And in theory, those could have been put in on a motion to dismiss. But instead, all they've put in is a self-serving affidavit from defendant Frank Kotaj and copies of a few checks to one of the employees, Joka Palusevic. These simply don't say anything about the core allegations in Mr. Sorge's complaint, namely that 1, he suffered from a disability, and 2, that as a result of that disability, he suffered an adverse employment action. That's all that the law requires at this stage. So all of the fact questions and fact disputes and purported facts the defendants have put in simply on a motion to dismiss are not relevant. Everything that Sorge says is taken as true and afforded the benefit of every favorable possible inference. He doesn't have to prove anything at this point, just have a good faith basis to allege it. And I want to take a moment to address defendants raised the issue. I was having some trouble hearing on the feed, but I believe they raised the issue of Sorge's amended complaint. Now, they claim that there's a contradiction in facts here, and I think the law is absolutely clear that at the pleading stage, a plaintiff is entitled to plead causes of action in the alternative. That's black letter law. Now, they claim that there's a contradiction in facts, but that's simply not true, because The core fact in Sorge's allegation is in all of Sorge's allegations, original complaint and verified amended complaint, is that he suffered an adverse employment action. And the way that works is first he was employed at the building, and then defendants purchased the building, and then after that he was no longer employed at the building. You can call that discriminatory termination. You can call that discriminatory failure to hire. We submit that discovery will show which of those it was. And Sorge does not have to elect a theory at this point without the benefit of discovery. In fact, he doesn't have to elect a theory at all until this case goes to trial. So, you know, defendants have, and they have no answer to that. That the issue is not that he said he was employed and then that he said he wasn't. The issue is all throughout he's maintained that he suffered an adverse employment action because of his disability. Defendants.
Any other questions for counsel? Thank you.
Yep.
Mr. Horowitz?
Your Honor, may I have it? Yes, and again, I would just circle back. Yes, I would just circle back to the argument that I was making on the initial presentation. The contradiction is in fact critical. There's not a dispute, at this point, there's no dispute that Mr. Sorge has a disability. But the claim that he was terminated necessarily requires that he was an employee, and there is no proof in the record that he was ever an employee. Confronted with the motion to dismiss on that original complaint, which only alleged termination, wrongful termination, plaintiff then proposes to amend the pleading to say, well, in a conversation 7 weeks later, the defendant appellants failed improperly to hire him. At that point, the building already had a superintendent for 7 weeks. On the morning after the closing, the new superintendent, the non-resident superintendent, goes to the building and collects the super's keys. At that point, Mr. Sorge certainly knew that he was not an employee, and there was no position that was open to be filled.
Any other questions for counsel?
And I'm happy to answer the questions the panel has.
Thank you. Thank you both.
Your honors and counsel.
Excuse me, I didn't hear what you said. You broke up.
Thank you, your honors and counsel.
Oh, okay. Thank you. Thank you both. This concludes oral argument for today. Court is adjourned.